Let's talk for a few minutes about direct question objections and when you can make an objection during the other side's direct examination of a witness. Now, many law students, especially those who have not yet taken a course in evidence, tend to get hung up on the various formal names of the objections that are available to be made. And you can very easily find a full list of those objections. But here's what I tell my team members. Common sense will get you pretty much as far as you need to get for a competition of this nature. The arbitration setting does not require formality. And if you hear a question asked of your witness and you are playing defense in this role, and you hear a question asked of your witness that is vague or confusing or it's compound, simply make the objection and explain the reason for your objection in plain English, in common sense. Arbitrators are not looking for formality. They're looking for, well, clearly articulated common sense objections to questions that are asked during the course of the competition. Now, a question on direct examination will be objectionable if it's vague, if it's confusing, if it twists the facts or assumes facts incorrectly, if it's actually two questions in one, if the question is complicated, or if it's hard to understand, or if you think it might confuse your client, then by all means make an objection. What if the question is asking the witness to speculate about something that did not actually occur or what maybe another person was thinking? It's objectionable as speculation. How about the hearsay objection? I must say, there is no objection in this tournament that causes as much consternation among law students as the hearsay objection. And if you have not yet had a course in evidence, there are a couple principles involved that can be quite elusive, and I found simply makes students insecure about lodging an objection and insecure about defending an objection that might be made to one of their own questions. You will have an important advantage in this competition if you master a couple basic principles about the hearsay objection. First of all, how is hearsay defined? Well, let me read this. Hearsay is a statement made out of court that is offered as evidence to prove the truth of the matter asserted. Here's an example. What did your cousin say to you about the condition of the house after the storm? Objection calls for hearsay. Listen to that question again. What did your cousin say to you about the condition of the house after the storm? Well, that's hearsay because it calls for an out-of-court statement, and it is being offered to prove the damage, in this case, from a storm that occurred at a rental property. Now, there are important exceptions to the hearsay rule, and the one that you will hear most frequently is that the out-of-court statement is offered to establish the fact that the statement was made and not that the statement was truthful. Now, this is something of a dazzling distinction, but it's important when you ask a question. For instance, let's say you want to prove that the cousins of one of the principals of your case teased him about the conditions at the rental property. You don't want to use statements from the cousins to prove the condition of the house. Rather, you're simply asking the question to draw forth the fact that your client was teased by his cousins. In that case, it's not hearsay, and that's how you would defend it if it draws an objection from the other side. Now, there are a double handful of other exceptions to the hearsay rule, such as an excited utterance, business records, a current statement of mental or physical state, and there are others. I find that in this tournament, it doesn't come up. The one exception to the hearsay rule that we hear all the time is, and it's a good defense, that the statements being elicited from the witness are not being offered to prove the truth of the statement. So go back and master these basic concepts about the hearsay objection, because it will come up, and you must be aware of this and plan for it when you are putting together your direct examination.